There's a small art supply shop in Royal Oak that I insure that sells supplies for cross-stitching. They do custom framing there. That policy is around $550 a year. On the upper end, yeah,
that's for a physical location. That's
and she does not own the building though. She leases the building.
Okay.
I'm not insuring that, but everything in it we insure. On the upper end, I have a custom furniture manufacturer. This guy's every bit an artist. He does a lot of drawings and things. He creates the furniture, but he's got a bigger business. He has employees, so he's got workers' comp. He's got business auto because he has several trucks. He rents the building, but it's full of all kinds of equipment. That total policy is maybe, I'm guessing, about $10,000 a year from what I can remember.
Tom Hoyt just said, "That's me."
Oh. Welcome.
Because he uses Davis as agent to insure his other. Hi, Tom. I want to, unless someone else has any more questions about commercial insurance, we could talk about that. Maybe get into that.
I just want to add one more thing, and then I'll be done.
Yeah.
One of the things we look at in determining the rates, and this applies to commercial insurance, specifically something called loss runs or your loss history. The more conscientious and responsible you are, the fewer claims you file, the better your rates are going to be. If you start having a lot of claims and things maybe seem a little suspicious, your rates are going to go up and up and up. And every time we do a commercial quote, we need to see loss runs. And if the loss runs are very reasonable and good, then the rates are going to be much lower.
And that's across the board. That doesn't matter what agency they go to. They're always going to ask to see what your basically looking at your history.
Your loss history, right?
Yeah. Damien, I want to talk a little bit about Trademark, if you don't mind. I know that sometimes a corporate logo or a tagline is Trademark, yes. But for everyday artists, like, why would we need to? What would we be trademarking? Anything?
So yes. So one, you have two types of trademarks. You have state trademarks under state law, and those are administered by the state of Michigan. Their department is called LAURA, L-A-U-R-A.
Mm-hmm.
And then you have federal trademarks. Those are done by our office. I'm way more familiar with the federal side than on the state side, but they are two independent, different rights. To obtain a federal trademark, you must be doing business in interstate commerce. That means you must be selling a service or a product outside the state of Michigan. You must have actual use to obtain a trademark. So there's generally four types of trademarks. There's the trademark that describes your business. So General Motors has a trademark on the name General Motors. They're in the business of making cars. Then you have product trademarks, Chevy, Cadillac, Corvette. Those are product trademarks. That's what's actually put on the product. So one is your business, General Motors, and one is your product, Corvette. Those are very different trademarks. The business is an operating entity, could be a person. You could have Damien Procari, photographer, and then you can have Damien's designs, which are the work that I'm actually selling. And then you have a service mark. So if your business doesn't actually sell a good, but rather it's selling a service like Dropbox, those are service marks because you don't actually have a piece of hardware that you hold where you can have a label and stick it on there. Then there's more unusual things when you've got bulk things like oil and concrete. But for the average artist here, it's going to be your business name and the products that you're attaching that to.
And why is it important? Why would it be important if we have copyright? What do we need a trademark for? What's the difference?
So again, a copyright is essentially the individual work.
Oh no. Hi, Dave. Where'd he go?
He's coming back. There he is.
Hi. All right, you're back.
So I'm a photographer. That's my business. I'm selling photographs. I can copy. I take 1,000 photographs a day. So I will have 1,000 copyrights. I can file a collection. But so let's just assume I have a collection of copyrighted works. My business name is Damien Procari Photos. and I sell mugs called Damien's Mugs. So the product is Damien's Mugs. The business is Damien Percari Photographer. And then the things the individual artworks or the individual copyright collections. So when do you need a copyright? So you really don't, quote, need a copyright. I'm sorry, I said copyright, I meant trademark. I apologize for misspeaking. You don't need a federal trademark. There are benefits. First benefit is if you're doing business in this particular class of goods. So you will have, my former employer, Ford, had a trademark in Ford, but there are a bunch of other businesses called Ford. There's Ford Modeling Agencies that was in the business of, of hiring models. So you can get a trademark for a particular class of goods. You have to pay a fee for every single class that you're in. Having a federal registration precludes other people from getting a trademark in that class. So one of the benefits is you're the only person selling Damien mugs because you got that federal registration. And so no one can stop you, and you, with your federal registration, can stop an imposter or counterfeiter who gets into that space. So the reason one obtains trademark registration is to protect the business or the products or the services you're in, to not confuse the public. So you have two people selling the same thing and with the same or similar name, and not to have people essentially usurp your goodwill. Once you become famous for selling these Damien mugs, some interloper comes in and says, well, gee, you didn't get a trademark in that. I'm going to come in, get a trademark, and start selling Damien mugs, and no one can stop me. So the benefit is that you did something cool and unique that's associated with you, and you want to make sure you get to continue using it so that that business lives on forever. Trademarks never have an expiration. They live forever as long as you renew them and you continue use. And so you can sell them and transfer them and et cetera, et cetera. So the reasons you would get a trademark is to protect your business. It has commercial value. You have to be in business. You have to be selling to get a federal registration. There is a very limited intent to use for a short period of time. For the vast majority of users, you have to be in business. You have to be selling something with that name in it. You have to have evidence of use with that name. You have to have a purchase order. It has to be an interstate commerce. You can't sell it to your mom unless she's in Ohio. But you have to have evidence of use, and you have to be using that mark in that class. So it has to be attached to the literal thing you're selling. So don't falsify these specimens.
Thank you. That's interesting.
There's actually a pretty good local example. I don't know, when the whole financial meltdown happened. I don't know who the individual is, and forgive me if you're watching, and I'll give you credit. But the guy who started making the Detroit versus Everybody shirts and started to do gangbusters on it. That's something you trademark, so that someone else couldn't take that phrase and then put it on a mug and use it. You can then claim damages. But a copyright wouldn't work in that instance because it's not the same sort of. So like if you have a design, like the Michigan hand or something that's unique to you and you're going to use over and over in a variety, that's more of a trademark than a copyright.
Yeah, very hard to copyright on short phrases, 2-word phrases. Much easier to get trademark protection.
Mm-hmm. Okay.
One thing I want to talk about. Wow, feedback. Thomas, you and I talked about this earlier, but Thomas and Steve, from a digital artist and photographer view, what are the important issues facing artists when they post their images online? And then I want to talk about when they're looking for images to add to their website or to their marketing campaign. So one is them posting online, what size image should they be posting? Should they be using that, what's it called, that stamp that keeps
watermarking?
That I hate so much. I hate watermarks. I think they ruin the painting, the image, and they don't really work. But what pains can artists take to protect themselves when they upload, but also when artists are looking for images to use, they can't just take an image online, screenshot it, and use it, especially for commercial use. You can't do that. So do you mind, both of you, talking a little bit about projecting and receiving?
Well, I can address that last bit that you just talked about, where if you find a piece of art that someone has done, you can't just take it and use it as your own. For example, though, you can, if you find a stock image of a pose, a human pose. I do this all the time. I see a pose, I like it. I don't trace it, but I dupe it or come up with my own take on it. And at the same time, if it's a stock image, I buy it. So I can at least say that, look, I really liked your artwork here, and I purchased it, and I did my spin on it. It was a photograph of a woman, and I did an illustration of a woman in a similar pose. So there's that. And I guess there is a fine line to walk with that as well. I suppose if you got too close, you could say it's fair use or parody or something along those lines, which is another matter entirely. So yeah, there's that.
Right.
But there's so many things. Go ahead, Tom.
Well, in instances like that, it's called a derivative work. And as long as you're not actually just taking the image and calling it your own, in terms of artistic expression, although I forget who that artist was that was just taking stuff off of Instagram. His whole thing is to appropriate.
Yeah, he just changed the comments that were with the photo.
Right, exactly. So that's a whole nother world, which we don't want to kind of go into. But a derivative work, if you kind of take a piece of something and put it in your own, mash it all up, as long as you're not directly copying that and making money, you can use it that way. But I think what you're talking about is that, you can't take any images. I was teaching years and years ago, and this was, kind of when the web was kicking off. And one of my students said, well, once you put it on the internet, then it's free, right? And I'm like, no, wait a second. Let's go back to basics. But people kind of have that idea that once it's on there, it's public use, but it really isn't. Now, if you're going to take a work and, as Steve said, use it for inspiration for yours, well, go ahead and do that. But if you take that work and then put it on your website for some reason as a design principle, technically those people can sue you. Now, again, we'll go back to the conversation if they've registered the copyright, if they find it, and then they have to present damages and stuff like that. So it's more of a moral or an ethical question of using works that you take off of the internet itself, which I think as artists, we should respect other people's copyright as much as we would want to respect ours as well. Now putting your stuff on the web, it's really, really hard to track anymore where that may go. I got a solicitation a little while ago, someone saying, hey, I saw your image in a magazine over here, or a blog post. Can I use it for mine? I'm like, I didn't even know it was on that first one. There are programs out there that are available, especially with photography and metadata, to be able to track that. But it's very, very time consuming. It's very labor intensive. So the best thing that you can do is when you put something on the web, make sure it's a very low res, like 1072 by whatever the other length of the image is. And this is for any reproduced work. It's not just photography. And make sure that it's 72 DPI, which is the monitor res. It'll look fine on the monitor. And then someone can't take that and use it for a brochure. They can't print it for printed material. That's kind of the best that you can do. The copyright, when you put that, or the watermark on it, again, as we explained early, is just a fail-safe for if you do go to court, there's no way that those people can say, I didn't know it was copyrighted. But let's be honest, anything that is out there on the web is copyrighted somewhere. The assumption is that it has been made by someone and it is copyrighted. So if you're taking it, you are stealing copyrighted material. Now, there's also stock agencies or open source or all of that gives free images for you to use for design templates for websites and all of that. So being a conscientious artist, go there first and take those images. Or if you are going to take an image off of the web for usage, contact the artist, find out who they are. Generally, I don't care if someone really does it. It's no big deal to me.
As long as they credit you.
Yes.
Exactly. Unless it's a corporate entity that has really deep pockets and they're going to use it for an ad campaign, that's a totally different thing altogether. They should be paying me licensing or licensing fees for that itself. And
Absolutely.
that I would pursue. But a single artist that takes an image, I'm not going to sue them. They don't have any money anyways, so it's really a matter of how kind of upstanding a person are you, and do you want the same respect given to you that you want from other people?
That is exactly the case. I've found in the past with digital images being shared and more or less stolen, I guess you could say, I've found that the creative community is pretty cool about contacting you if they see your work. Like it's happened to me on Instagram where someone has said, hey, so-and-so used your artwork on their collage or something, and they posted it. So I looked, and sure enough, they did. And I said, hey, that's not cool. And they took it down, which was great. Or in the past, I've seen illustrations used for ad campaigns with other project or other clients and such, and I felt that it was my duty as a conscientious artist to contact those people. And sometimes they're thankful, sometimes they're like, yeah, I don't care, but at least you did your part. So be part of the community and do right by your fellow artists.
Doesn't Google have an image search where you could upload an image, search Google, and you can see where that image is used across the web? Oh, really?
Exactly.
Yeah.
It's kind of there, but it's really not. And unfortunately, a lot of the programs that people use for resizing will take out the metadata of it. So you can't search that way. It's almost a full-time job anymore to keep track of where all of your images are going.
Okay.
And there's a couple questions here that, the watermark does give you an added layer of protection, but only if you have it registered with the Copyright Office and only if you can prove damages. So the disadvantage is that it looks crummy. It's on part of the image, and it's more of an aesthetic thing than it is a protection.
It is. It ruins the image for.
So if you're doing due diligence, on the front end of registering your copyright, with the office and all of that, it gives you a little layer of protection, but I don't know. I'm on the fence about it. I personally don't like them all that much. So
Sue has a couple questions. My artist website states with date and the circle. All image property of the artist. So that's what it states on her website. It's a blanket statement for her website. How do I protect myself if someone uses my image from my website and tries to pass it off as theirs?
Everything we've been saying, make sure the image is registered with the Copyright Office, or you can't do anything about it. I would first contact those people if you know that they're using it, ask them to take it down, or tell them that you'll sue them for the actual usage of the image. That generally, every time I've done that, it's led to a takedown of the images being used in an inappropriate manner. And then if that doesn't happen, just follow up legally through the Copyright Office. Whoever told you on Facebook that there was nothing that could be done is actually incorrect. You could have done that, again, if you follow these procedures in this particular order. Now, one thing that's really important is that you cannot reach out to someone or file a lawsuit and expect to get any damages if you don't have that copyright registered. So if you find it online and you think it's a massive infringement, like again, from a corporation that's using it that could actually pay you, and you could justify licensing damages, don't do anything until you go and register that right away. You won't have any ground to stand on if you contact them and then register the copyright. At that point, your case is shot. There's nothing that you can do about it at all. So
yeah, there's one additional remedy, and you can go after the service provider if the service provider is hosting copyrighted images. There was a plastic surgeon in Detroit that had all of his before and after pictures taken by a competitor. So,
okay, yeah.
Wow.
So yeah, again, it's really just, once you get the basic steps, it's fairly easy to do. If you don't do it, you're kind of SOL. If you do it, then you have a chance of it. And again, if you want to put the copyright on so you can avoid a little bit negotiation, did they have ill intent or did they not? That gives you a little bit more wiggle room there. Yeah, but it's going to happen. It's going to happen. It's happened to me a ton. It will happen. It's a matter of whether it's worth you actually pursuing it, going on the lawsuit, and can you claim damages for that in any significant way? That would be my judge of how far I take it. Most of the other times, it's just a pleasant, oh, hey, I didn't know. I hope you didn't know that you took my image. Can you take it down? If they get snarky, then you can yell at them, and then take it from there. It's kind of a process that you go through with all of this. So.
Scott asked a question that we may have already answered, but we'll answer again because I think he may have jumped on a little bit late. Let's say a painter who creates dozens of works per year, do they have to register every piece? Is it a cumbersome process to do this individually? I think Thomas and Damien, you mentioned we could do like 100 pieces in one shot.
You can do up to 750 if it's a photograph. And so if you've got, a portrait, you don't actually send the portrait to the Copyright Office. You send an image of the portrait to the Copyright Office. So I don't know the exact specifics on that, but you would be able to register a collection of portraits in your registration. You can do them one-off. So, for example, with a portrait, I don't know how the items were commissioned. So there's different rules for commissioned artwork. So if I commission you to do a portrait of me, that's under one rule in the Copyright Office for registration versus I took a photograph and I'm reselling it. So there's different rules for commissioned artwork. But you can register a collection of works. But I would probably look at what my business strategy is. So, for example, if I have 10 portraits and I'm selling one to Tom, the second one to Dick, and the third one to Harry, I very likely will want to have 3 bills of sales with 3 copyright systems. Maybe the Tom one, they don't get the copyright because they only paid me $1,000. The Harry one, where he commissioned it and he gave me $100,000 when he wants to own the copyright so that he can make mugs and paintings and everything else. A block registration might not be helpful for that business plan. So I think you should always develop the business plan first, and then the legal instruments will follow based on what you want to do. So if everything is always the same, fine. You're selling postcards at your store, not an issue. Got different types of commission work. I might need 3 types of registrations based on how I'm selling it.
Okay. This goes into a whole nother, they just brought up another conversation. I don't even know if we really have time to cover it, but it's particularly for photographers in that a lot of people are getting into the business where, we won't even go into work for hire now. That's a totally different thing altogether. But people in their contracts will often want to own the copyright of the image that you are giving to them. And just to touch on that, the difference between owning a copyright of the image and a licensing agreement for the usage of that image is generally about 100 times greater. Yeah. So for example, if the licensing agreement for an image for usage is $1,000 and they want the copyright, you generally should charge them $100,000 for the copyright of that image. Now, most people who want the copyright don't understand the difference here, and it's kind of like a rights grab that's been going on for the last 10 years on that. I just want photographers in particular to pay attention to, if you are licensing images and they want the copyright, it's a whole different conversation altogether. This is not the Copyright Office. This is the person who wants to use that image. And then secondarily, I know an artist in town that entered a competition, didn't read the fine print, and now her images are being displayed as banner advertising because of the competition, because in the competition, it said, we have full rights to use this and own the copyright of this image if you submit to the competition. I would say that 80% of photography competitions out there are now asking, buried in the print, Nikon even does this, that they now own the rights to that image. So you want to be really, really specific and really careful about the rights that you are giving away by having perceived exposure for entering these competitions. I mean, it's not about registering copyright, but it's about copyright ownership, your ownership on that. If anyone ever says they want to buy the copyright for something, it's a red flag. At that point, and you don't know any better, contact an attorney immediately, that woman you were talking about, because you can lose hundreds of thousands of dollars that way. I mean, actually $100,000. So be really careful, especially with photography these days. Just needed to throw that out. It's a really strong and passionate thing for me. So.
It is, and I've heard lots of stories, unfortunately. I'm going to jump back to James. Earlier in the evening, he asked if there's a packet from the Copyright Office. I remember that there was a packet they sent you for copyrights. Is there still a packet, or just everything's online now?
Everything's online.
And the thing for paper is triple electronic. They're strongly moving everybody to electronic filing.
Mm-hmm. Right, and just something from Copyright Alliance came out today that all closed now because of Corona. They're not even going
opening packages.
If you had sent something in, expected in about a year that you'll get a response on it. So I wouldn't even bother going that route right now. And it's not even efficient for artists, really. The online thing is very easy.
It's much better.
Go that route.
Michelle Sider asks, she says, I took a video of my mosaic rather than a photo. Does this discourage people from stealing the image?
Probably.
A little bit, I suppose. Yeah.
I mean, unless they're going to use it on YouTube or something along those lines, they're more than likely won't use it for commercial purposes. It'd probably be more of a share thing than anything else. But it depends on the platform.
Yeah,
How would you even grab someone's video?
Yeah.
I'm not a video person. So another question that came in is, yeah, it's fine when juried shows or even the better photo competitions, if they're asking for, and a lot of times the language will say unlimited use in perpetuity worldwide. That isn't necessarily the hard line on it, but the line is that it will only be used for promotion for the show associated with that particular event. Mm-hmm. If there's language in there, fine. Actually, if someone wants to use my image for promo for a show, you bet, that's free advertising for me. But as long as it explicitly says the copyright is retained by the artist and it is only in association with this show and the promotion for this show, that language needs to be very specific in that. The other worldwide in perpetuity is just general boilerplate language now that means they can use it on the web and they can use it on print because they don't really know what they're going to do with it. But that other language is very, very important, that it's very specific about what the usage will be and that you retain the copyright for it. Not like we can now use this for our advertising for any show that comes up in the future and you relinquish your rights to being able to do anything about that. That's not cool language, which a lot of the photo stuff does say, the photo competition. So
yeah. Mm-hmm. We've hit the 7 o'clock mark. Woohoo! Wow. Perfect. Thank you. That was amazing. All of you had just wonderful experiences and expertise, and thank you. I really appreciate you being here, and I appreciate everyone coming to our Facebook group, asking questions, being a part of this Creative Fuel Growth Series. I'm really excited about doing it this year. Our next event is Telling Your Story with Prologue Detroit. We're going to talk about marketing and PR and branding, but primarily telling your story. How do you, as a creative, as an artist, as a creative business owner, talk about yourself? You know, it's really difficult for us to do because, and I say that loosely because a lot of artists, that's all we do is talk about ourselves. But for a lot of artists, it is difficult to talk about ourselves because it's very personal. You know, we're kind of creating from here, we're sharing our souls. How do you really speak about that? Not in a way where you're just talking about it, but in a way that you're really engaging your audience, because ultimately our goal is to sell things. Otherwise, it's just a hobby. So how do you tell your story effectively so that you can gain more clients, more prospective clients, galleries, retailers, whoever it is you're looking for? Really take that important information about yourself and speak it in a way where it's going to benefit you, and then be able to use that on your website, your marketing materials, anywhere digitally or written. So that's Telling Your Story. You can go to embracecreatives.com. Join us if you're not a member, but either way, you can sign up for free, and we'll be seeing you at the end of April. So Thomas and David and Damien and Steve, thank you so much for being here. I really appreciate it. Thank you.
Thank you for having us.
Thank you.
Have a wonderful night.
Bye, everybody.
Be
Bye.
safe.